Hello everyone, my name is Mariam Dominguez, and today we're going to be learning a little bit more about legal guardianship. Throughout this presentation, we're going to learn exactly what guardianship is, the different types of guardianship, and even alternatives to guardianship, as well as what is done to determine a need for guardianship, such as the legal requirements, clinical evaluations, how it's determined who the guardian will be, determining what the guardian shall do, and a little more on advanced directives as an alternative. So what exactly is guardianship? Well, according to our textbook, guardianship can be defined as a legal mechanism by which the state delegates authority over an individual's person or estate to another party. Guardianship can be appointed over a minor, over elders. It can be appointed due to mental incapacitations as well, such as mental illnesses, disease, or other mental deficiencies, sometimes seen with traumatic brain injuries, for example. One can have guardianship over one's person, which means they would have the authority over healthcare decisions, or they can have guardianship over one's estate, which means they would have authority over all contracts to sell one's property. A conservatorship is when one would have authority of both, authority over contracts to sell one's property and make healthcare decisions. These guardianships can also be categorized into two different subsections, general and limited. In general guardianships, a person would have total authority over the ward's person, estate, or both. In specific or limited guardianships, a guardian would have the authority to make specific types of decisions. So, for example, a guardian may have the authority to make only specific treatment decisions, such as specific course of treatment proposed, or non-routine medical decisions such as surgeries. The ward, or respondent in the petition, would remain free to make other healthcare decisions for themselves. Limited guardianships are typically less common, and more about these limits of guardianship can be learned by watching attorney Andreas Leewald's video on the limits of guardianship for a person diagnosed with a mental illness, which will be linked at the end of the video. There are also a few alternatives to guardianship. One common alternative is an advanced directive, such as representative payee arrangements, which allows people with mental illnesses to appoint a surrogate decision maker with respect to one or more specified decisions during a period of competence. This approach, of course, requires that the individual be competent at some point to understand the relevant issues and designate a surrogate. Supported decision making seeks to maximize the ongoing and active involvement of the principal in the decision-making process, so the ward would be able to assist with some of those decisions appointed to their representative or guardian. When determining a need for guardianship, there are multiple factors that play into effect, such as legal requirements, different clinical evaluations, determining who that guardian will be, determining exactly what that guardian would be able to do, and more on advanced directives as alternative options for guardianships. It's important to note that there are minimal legal requirements for guardianship. One requirement is known as de facto incompetence. This is when an individual is found to be incompetent by a physician, so they're incompetent in fact, but that has not yet been determined by legal proceedings. These legal requirements also lack rigor. In fact, multiple experts have tried pushing reform to ensure that the rights and the autonomy of the ward remain protected. The only true requirement of the petitioner is that they must prove the ward's incapacity to care for themselves or their estate. In 2003, a guardianship analysis was conducted where they analyzed over 566 guardianship cases. The experts found that 25% of those hearings lasted less than 5 minutes. They also found that 58% of the hearings lasted less than 15 minutes. The ward was found not to be present over 66% of the time, and the expert was only found to be present about 8% of the time. Clinical evaluations are another step in the guardianship process. These evaluations are not required by many states, however, they must be provided if demanded by the petitioner or the subject. There are multiple different kinds of clinical evaluations. Some of the ones we see most commonly include an assessment of the independent activities of daily living, or IADL. Here, the evaluator will assess the individual's ability to complete regular activities on a day-to-day basis, such as maintaining their hygiene, cooking, shopping, etc. The evaluator during these evaluations must consider things such as physical impairments, like hearing loss or vision loss, as well as other environmental conditions to ensure that the individual is assessed for their mental capacity and there are no external factors that are affecting their decision-making at the moment. Another form of clinical evaluation is known as DAFS, or Direct Assessment of Functional Status. During these evaluations, the respondent performs activities while being evaluated. They'll perform activities such as using checks, transportation, communication, and the evaluator will assess their ability to do so. The last and also commonly used assessment is an assessment of capacity for everyday decision-making. Here, they assess the capacity to make decisions with regards to solving one's own functional problems. Following these assessments, the respondents are provided with written information on functional problems and options on how to address them, as well as the risks and rewards of each option. This form of assessment is meant to minimize the impact of short-term memory problems. Guardianship can be appointed to friends, family, and sometimes even government employees. Guardianships are most commonly appointed to family members. However, sometimes there are conflicts of interest that arise, especially when dealing with money. Family members are also less likely to be impersonal, as their close relationship with the respondent can sometimes cloud their decision-making. Government employees, on the other hand, such as sheriffs, lawyers, and social workers, are often overworked and overwhelmed, and likely have less interest in proper care management for the respondent. It's important to note that experts don't usually interfere and typically only do so when conflict becomes apparent, such as during a divorce case. The guardian is expected to act according to an objective test, which would be what action would be the most effective in serving the ward's best interest. The guardian is also expected to make a subjective substituted judgment, which is to decide in a way that aligns with what the ward would have decided if they were competent. When the ward or respondent shows at least some level of understanding, advance directives are often suggested. One commonly used advance directive is a living will. These living wills are created during a period of competence and are used to indicate one's desires regarding treatment should they become terminally ill or incompetent. The next is known as a durable power of attorney. These advance directives cover non-terminal situations as well, and can include direction regarding property or assets. Lastly, psychiatric advance directives allow persons with mental illnesses to state in advance the treatment they would or would not consent to in the event that they became mentally incapacitated. Attached in this slide are a video regarding the limits of guardianship for a person diagnosed with a mental illness, as well as a discussion question to consider. What changes, if any, should be made to the process of appointing guardianship to ensure that the ward's autonomy remains protected? Should clinical evaluations be required for every guardianship hearing? And if so, which assessments do you feel are most effective in determining incompetence or incapacitation?